morning. This is not legal advice. This is not financial advice. This is for entertainment and education purposes only. And everything I say is my opinion. Um, if you like the information I'm giving you, please subscribe, hit the like button. I really appreciate it. Okay. One of the elements of my lawsuit was antitrust and monopolies, and I believe that Citadel is in violation of United States antitrust and monopoly laws because they're actually the hedge fund, the market maker, and the dog food. Okay, first we're going to start off with what are antitrust laws, and I'm going to give you the Wikipedia definition. Antitrust laws, also referred to as competition laws, are statutes developed by the U.S. government to protect consumers from predatory business practices. And remember that part, predatory business practices. They ensure that fair competition exists in an open market economy. These laws have evolved along with the market, vigilantly guarding against would-be monopolies and disruptions to the productive ebb and flow of competition. Now, if Citadel is controlling the hedge fund, the market maker, if they're the hedge fund rather, the market maker and the dog food, is that fair competition? They control the ebb and flow of every transaction. Okay? Now, antitrust laws are statutes developed by governments to protect consumers from predatory business practices and ensure fair competition. What Citadel does not ensure fair competition. Antitrust laws are applied to a wide range of questionable business activities, including market allocation, bid rigging, price fixing, and monopolies. In my opinion, when it comes to Citadel, we're more focused on the price fixing and the monopolies. Okay? Core U.S. antitrust laws were created by three pieces of legislation: the Sherman Antitrust Act of 1890, the Federal Trade Commission Act, and the Clayton Antitrust Act. Okay, now here's a basic definition of these three acts. Obviously, it's more complex, but these are just a basic definition of what these antitrust laws are. Okay. The Sherman Antitrust Act intended to prevent unreasonable contract combination or conspiracy in restraint of trade, and monopolization, attempted monopolization, or conspiracy or combination to monopolize. Violations against the Sherman Antitrust Act can have severe consequences, with fines of up to $100 million for corporations and $1 million for individuals, as well as prison terms up to 10 years. The Federal Trade Commission Act bans unfair methods of competition and unfair, deceptive acts or practices. According to the Supreme Court, violations of the Sherman Antitrust Act also violate the Federal Trade Commission Act. Therefore, even though the FTC cannot technically enforce the Sherman Antitrust Act, it can bring cases under the FTC Act against violations of the Sherman Antitrust Act. So these are different tools that if the FCC wanted to do their job, they can utilize to ensure a fair market. But somehow they sit on the sidelines. Okay, now the Clayton Antitrust Act addresses specific practices that the Sherman Antitrust Act may not address. According to the FTC, these include preventing mergers and acquisitions that may substantially lessen competition or tend to create a monopoly, preventing discriminatory prices, services, and allowances in dealings between merchants, requiring large firms to notify the government of possible mergers and acquisitions, and imbuing private parties with the right to sue for triple damages when they have been harmed by conduct that violates the Sherman and Clayton Acts, as well as allowing the victims to obtain court orders to prohibit further future transgressions. So what that's saying is that if you have realized losses that violate the Clayton Antitrust Act, you can actually sue for up to 3 times of the amount that you lost because of their actions, because of their violations of the Clayton Antitrust Act. And also you can ask the court rather to bar them from practicing these illegal acts into the future. Okay, the bottom line at the core, the antitrust provisions are designed to maximize consumer welfare, Supporters of the Sherman Act, the Federal Trade Commission Act, and the Clayton Act argue that since their inception, these antitrust laws have protected the consumer and competitors against market manipulation stemming from corporate greed. And remember that, corporate greed. Through both civil and criminal enforcement, antitrust laws seek to stop price and bid rigging, monopolization, and anti-competition mergers and acquisitions. First of all, Citadel, the way their business plan works, does not provide a fair and competitive market for the retail investors. They have a monopoly on the market because if they're the hedge fund and they decide we're going to buy 1 million shares of AMC, for example, and those 1 million shares don't exist, as the market maker, they will just fabricate the 1 million shares and short them into the market or sell them into the market. Okay, but as far as Citadel is concerned, I'm going to go into price fixing. Okay? And this is what price fixing is. Price fixing occurs when the price of a product or service is set by a business intentionally rather than letting market forces determine it naturally. Several businesses may come together to fix the price to ensure profitability. Now, here's where price fixing comes in as far as AMC, as far as I'm concerned, in my opinion. If they're routing our sell orders into the lit exchange and keeping our buy orders in the dark pool in order to manipulate the price, what they're doing is they're price fixing. They are price fixing the value of AMC and GME shares. And the statute is very clear that it's supposed to, by letting the market forces determine it naturally. And Citadel, as a hedge fund, the market maker, and the dark pool, is not letting it occur naturally. They're controlling the price the way they manipulate the dark pool. Okay? Now, let's go into what a monopoly is. And this is the Investopedia's opinion, or Investopedia's definition of a monopoly. A monopoly consists of a single company that dominates an industry. A monopoly can develop naturally or be government sanctioned for particular reasons. However, a company can gain or maintain a monopoly position through unfair practices that stifle competition and deny consumers a choice. And back to, once again, they're the hedge fund, they're the market maker, they're the dark pool. Do consumers really have a choice? They don't. Citadel controls the market, and they control just about everything that goes on with any share that they want. And until we shut down the dark pools, until the SEC decides to do their job and enforce these antitrust monopoly acts, then the retail investors will be at the mercy of the hedge funds. We pay the SEC, we pay the DTCC, we pay all these government agencies to protect our interests in the retail market, and they don't do that. Please, any comments, any questions, leave them at the bottom. I appreciate you taking your time out to listen to my video, and hopefully we'll be successful in the lawsuit. Please subscribe, hit the like button. Thank you very much.